NACDL is the association of the nation's criminal defense bar.
This project is supported by grant number 2019 YABXK001, awarded by the Bureau of Justice Assistance. The Bureau of Justice Assistance is a component of the Department of Justice's Office of Justice Programs, which also includes the Bureau of Justice Statistics, the National Institute of Justice, the Office of Juvenile Justice and Delinquency Prevention, the Office for Victims of Crimes, and the SMART Office. Points of view or opinions in this program are those of the presenters and do not necessarily represent the official position or policies of the U.S. Department of Justice.
Greetings, everyone. Thank you for joining us today for a conversation on prior conviction, impeachment, and race, conducted in collaboration with the National Association of Criminal Defense Lawyers, the NACDL. My name is Assis Passin, and I'm a postdoctoral fellow at Boston University working on evidence equity, and I'm soon going to be joining the University of Maryland as a visiting assistant professor of law. I will be moderating today's conversation. I'm joined by two of the leading scholars on prior conviction, impeachment, and race, Professor Montre Carradine from the University of Alabama School of Law, and Professor Jasmine Gonzalez-Rose from Boston University School of Law. So with that quick introduction, let's just straight jump into the topic. My first question is for you, Professor Carradine. Could you share a bit about what really prior conviction impeachment is?
Thank you, Assis, and thank you for that wonderful introduction. I appreciate the opportunity to participate in this important program. So prior conviction impeachment is a mechanism by which litigants, whether it be plaintiffs, defendants in the civil context, or prosecutors and defendants in the criminal context, it's a way in which they are able to challenge the credibility of a witness on the basis of their prior record. Typically, we're talking about felonies, but not always. There are some limited circumstances in which non-felonies would also be used for impeaching somebody's credibility. But basically, what the rules allow is for a challenge on the basis of someone's prior record, a challenge to their credibility, to say that they're less truthful because they have a prior record.
Yeah, thank you so much for that primer. I wanted to ask, what are the origins of prior conviction impeachment, and does this have anything to do with race or racism?
Very good questions. So prior conviction impeachment came about somewhat as a compromise to the earlier kind of process or procedure in the criminal system, whereby convicted felons and certain other parties, people of color, often Black people in particular, weren't able to testify, the so-called competency rules. So the system kept out so many people from being able to testify, and those rules started to be liberalized at some point. And as they were liberalized, we held on, or the system held on, to some of the vestiges of the prior system, and decided that we'll let you testify, but you'll be impeached with your prior record. So felons in particular, they could testify, but they would be impeached with their prior convictions. And that's how the prior conviction impeachment process really developed. And in your other question about the racist origins, it's important to think about what was going on at the time that the rules, the competency rules, were being liberalized, but then also we're holding on to the vestiges of the prior system. What's going on is that Black people are in some ways being freed from slavery, but at the same time being re-enslaved in a different type of system, and the new slavery, which was the penal system, the incarceration system. So we had the convict leasing program. Really prevalent in the South, whereby Black people were basically still being enslaved, just through a different way. And so Black people are being targeted at that time, largely as participants, if you will, unwilling participants in the penal system. So the people most likely to have criminal records would be Black. So if you look at what's going on at the time that the prior conviction impeachment rule is being developed, it's right alongside the mass incarceration of former slaves.
Thank you, Professor Carradine, for sort of like grounding this like evidentiary practice in racist witness competency rules.
Mhm.
Let's turn now to modern day evidentiary practice. Are there any racial implications of sort of the use of prior conviction impeachment? And let's continue with you, Professor Carradine, and then we will hear from Professor Gonzalez-Rose.
So for the racial implications for the modern day practices, the use of prior conviction impeachment, well, I mean, we see so much of what we saw before. I mean, it's just a continuation of history, right? We have mass incarceration of Black people, not just Black people, other people of color as well, Indigenous people, Latinos. We see just an explosion that we see, the same type of explosion that we saw with the emancipation of slaves. So the racial implications are still there. When you have a disproportionate number of the people who will have the types of convictions that will be impeachable, if you will, under Rule 609, there's a racial component there. There's a racially disparate impact. When you think about the ways in which people are criminalized, the drug laws, think about in the juvenile system, for example, when children are waived into the adult system, and then they'll have a felony record that they can't expunge, that won't be subject to the more liberal, if you will, exception under Rule 609. There's some exceptions under 609, by the way, and one of them makes it difficult to use juvenile adjudications. But often youth of color don't get to take advantage of that because they're being waived into the criminal system. So there are a number of ways in which the criminal process, which targets unfairly people of color, lends itself to creating a disparate impact under 609.
Yeah, thank you so much for that. Professor Gonzalez-Rose, would you like to add something to this?
Absolutely, absolutely. I really agree with this. So when we're thinking about racism has increasingly been defined more broadly, not just individualized, intentional discrimination, but we also know that racism manifests in structural ways, in systemic and institutional ways. And often the way that we see this are in these racial disparities. And so I would argue that prior conviction witness impeachment rules are indeed racist. And they are for, at least 4 reasons. One, they is this racially disparate effect, and there always has been, and there continues to be. 2, they actually give evidentiary value to products of systemic racism. So things that Professor, Carradine was talking about, these disparities, these injustices in the criminal system of justice or injustice. And third, they trigger racial bias. And that's related to racial character evidence, something that both myself and Professor Carradine have written on. And finally, they silence people of color in ways that are reminiscent of historical race-based witness competency rules that Professor Carradine mentioned. And all of this applies to any witness, but it's particularly acute when we're thinking about criminal defendants who take the stand in their own defense. And so focusing a lot on that. So going to that first point, and it's already been touched on, but I just want to hammer it home. This idea of prior conviction impeachment and its racially disparate impact on witnesses of color. So here we know that people of color disproportionately have criminal convictions. And this isn't because people of color are more criminally inclined. Actually, social science studies will tell us that white people, people of color, people of all different races and ethnicities will engage in criminalized conduct at similar rates.
Mhm.
However, there are these extreme disparities in how people of color are policed and how people of color are criminalized. So here, people of color have convictions because of systemic racism. And this is systemic racism at every stage of the criminal justice system. So Black and Latinos and Indigenous Americans are more likely to be over-policed, profiled by law enforcement, be stopped, frisked, arrested, charged, indicted, and coerced or pressured into pleas. They're more likely to be found guilty by a jury and more likely to be sentenced more harshly than people who are white. And so all of this leads to this social phenomena of more people of color having convictions, particularly having felony convictions, which then can be used against them to question their truthfulness, their credibility, if they testify at trial. And so that's one concern. Another concern is thinking about how prior conviction impeachment gives evidentiary value to systemic racism. So all that systemic racism in the stops and the frisks and the pleas and the convictions, all of that manifests into this evidence, right? This evidence that is a criminal record. And then this criminal record is then brought up in court when a witness testifies, right? So here what we have is this end result that's really manufactured by a racially unjust system of law enforcement, of prosecution of people of color, and these products, right, these racially disproportionate convictions are then employed under Federal Rule of Evidence 609 or its state counterparts to simply say that witnesses of color are not credible, that they should not believe. And this is very concerning, and it's really concerning when it is a criminal defendant who is the witness. The other thing is that this evidence of prior convictions, it can trigger kind of latent racial prejudice, right? So the admission of prior convictions against criminal defendants of color who have testified as witnesses, this can trigger racial bias, right? The probative value of evidence that a witness has been convicted of a crime, particularly when it doesn't involve crimes of dishonesty or a false statement, they have very limited probative value as to actual truthfulness on the stand, right? If it's a drug conviction, perhaps a simple assault, what does that really tell the jury, the fact finders, about someone's ability to testify truthfully on the stand? And so here, prior convictions are admitted under these rules. Really, what I would argue, less for showing character for truthfulness, but more as racial character evidence, right? Something that conjures racial stereotypes or activates other racial bias. And so I've written about racial character evidence, and I've defined it as a way that race is used really as kind of de facto informal proof of a person's character. It describes how race, in tandem with racial stereotypes and bias, is relied upon, or it's emphasized to establish a person's character propensity to be not just truthful or dishonest, but also to be peaceful, violent, or a variety of other traits. And so when a fact finder learns that a criminal defendant of color has a prior conviction, that can trigger negative racial stereotypes and notions about Blackness, for instance, if the witness is Black, or about criminal propensity in Latino or Indigenous communities. And it's like ringing a bell. Not only does the fact finder already know that the witness is a person of color, but then they're starting to hear they're that type of person of color, someone who may be dangerous or who may be criminally inclined. And so it's particularly dangerous to be utilizing prior conviction impeachment against defendant witnesses there. And then I want to kind of conclude with something that Professor Carradine mentioned. Rule 609, prior conviction impeachment, it silences witnesses of color, and it does so in ways that are very reminiscent to race-based witness competency rules. So in the 18th and 19th century in the United States, all over all that, this isn't something that was just in slave-owning states in the South, but even up in the North, in New York, for instance, and out west in California, people of color could not testify either at all. Usually these were through statutes or judicial decrees that said that Black people, Indigenous people could not testify, but then that was extended to Latinos for being mestizo, being Mexican Americans who were a combination of Indigenous heritage. And it was also extended very famously in a case of People versus Hall in California against people of Asian descent, that they could not testify, or they could not testify against a white party. And so here we had silencing really on the basis of race. And so if we zoom forward to the present and we think about this systemic institutional racism, where 1 out of 3 African American men have a felony conviction. Again, not because of any increase in criminality, but because of over policing and over criminalization. Then we have 1 out of 3 African American men in the United States. If they're a witness at trial, their credibility is going to be questioned. And if they happen to be a criminal defendant, they're going to be stuck in a catch-22 of having to determine, do I take the stand and testify on my behalf, which is my constitutional right to do so, and then have my prior convictions come in and have that used against me, have that inflame racial stereotypes, or do I not testify because I'm afraid that prior convictions will come in and be used unfairly against me, and not be able to say my side of the story. And we know that juries are more likely to convict when they don't hear from the defendant, and if they hear of a criminal conviction. So it's very challenging, and there are tremendous racial implications.
Thank you so much. Professor Carradine, do you have anything to add here? Should we move on to our next question?
So the only thing I would add here is that in my first article that I wrote about Rule 609 and race, I made the argument that basically, as Jasmine said, that all of these issues, the issues that we see in the criminal justice system as applied to to people of color, Rule 609 then gives evidentiary value to all that, legitimizes all of that, and says this is good evidence. And I theorized that basically when a Rule 609 conviction comes in, the system, the criminal system, acts as a hearsay declarant that basically we have an out-of-court statement saying that this person is not believable because of their race. Not only not believable, that they're also a criminal because of everything that that Jasmine just told us. And so my argument is that based on all the problems in our criminal justice system today, it's not only a hearsay declarant, it's an unreliable hearsay declarant, and that we shouldn't give value to evidentiary value to what the system says. If you think about it, a system that disproportionately targets large segments of its community or any segment of its community isn't a reliable system. Why do we give evidentiary value to that system? And in every case, we need to try people anew, not give evidentiary value to what the system said before, because we really can't trust the system. We're trying, right? We're trying to move toward a fair system, a more just system, but we are not there. We're a long way from there. And so we shouldn't give evidentiary value to prior judgments, to pronouncements of this system that is racist historically and today.
That is so powerful. Thank you for sharing, both of you. And it's super sad and unjust just the way the system is playing out. Given that you've identified all these racist kind of outcomes of this evidentiary rule, my final question for you is, how do we move forward? What can be done and what should be done?
That's such a great question, right? So we don't want to just critique what the law currently is and what the rules currently are, but how can we make them better? And how can we really do this in a way that adheres to our principles of justice? And increasingly, advocates are saying, prior conviction impeachment rules like Federal Rule of Evidence 609 should be abolished, especially when used against a criminal defendant as a witness, and especially when the conviction has nothing to do with an offense of a false statement or dishonest act. So when it's not perjury, really, how is a prior conviction relevant as to a witness's truthfulness? And there are current efforts to this end. And so I think this is really important. And it's important to note that in Hawaii, for instance, also in Kansas, prior conviction impeachment cannot be used against a criminal defendant witness. So that's one thing, and that there are current efforts, and those should continue. In terms of working within the current rules framework, we really need to be sure that the balancing test within the rules. So most prior conviction impeachment rules have a balancing test in terms of admissibility. And this is balancing the probative value as to truthfulness as a witness against or dishonesty against the risk of unfair prejudice. Now, sadly, some jurisdictions like Oregon do not have a balancing test, but most do have a balancing test. The problem is that the practice in courts is often to not rigorously apply that balancing test. Often it's just a practice of, oh, well, in this jurisdiction, drug distribution, drug possession, simple assault, whatever it is, they come in to impeach without engaging in that balancing test. So really encouraging, defense attorneys to ask for a real, true weighing, encouraging prosecutors to do the right thing and, really engage in that test, and also thinking about, jurists, so thinking about the judges and judges, requiring that the rules be followed, right? I think it's incredibly important. And when we're thinking about prejudice, we also need to think about racial prejudice, right? think about how racial stereotypes can be inflamed. And that's something that needs to be articulated. I think it's really important. So it's imperative that we move away from this archaic, this unscientific, should I say, not evidence-based rule. Several scholars have written about how this rule really doesn't have a scientific basis. And ultimately, I think what Professor Carradine and I have talked about here, we need to move away from this racist practice of prior conviction impeachment.
Mm-hmm. Yeah, I agree. And we also need to talk about prior impeachment or prior conviction impeachment alongside other practices that hold against individuals their record. So prior conviction impeachment needs to be discussed right there with ban the box efforts, with felony disenfranchisement. It needs to be discussed right, it needs to be a part of that conversation. We have to move beyond kind of the evidence scholars talking about it, and even lawyers talking about it. So I would encourage all of you to talk about this in your communities when you are invited to speak on issues with respect to race, for example, and justice, social justice. Include discussions about this. This is a huge deal. And because it's an evidentiary rule, I don't think it gets the attention that it merits, but it's very important, and it's putting people unfairly, unjustly in prison and ensnaring them in kind of a cycle of incarceration. And this is something that we really need to discuss beyond kind of the legal circles and the academic circles. Talk about it in your communities. We need to make this more of a national reform issue, right up there with those other areas that I talked about.
That's an incredible way to end today. I just want to say thank you to both of you for sharing your expertise and your work with us on this extremely critical subject. And we're walking away with kind of understanding why this is such an important topic and why it warrants attention, not just from the legal community, but from folks outside the community, because it is just so important that this racist rule sort of we get rid of it, and it is not a part of our legal system or part of evidentiary practice anymore. So thank you both for joining us, and thank you to everyone for engaging with this important issue.
And thank you so much, Assis, for moderating this important conversation. And thank you to Monterey Carradine. You really were the first to write in this area, and everything that I've written has been informed by your work. So it's always an honor to be able to present and to be in dialogue with you. And thank you to the National Association of Criminal Defense Lawyers for this opportunity to share our thoughts and work on race, racism, and prior conviction rules. And most importantly, thank you to all the lawyers, judges, students, and everyone else who are engaging with this conversation and this important issue.